Hello and welcome back to our YouTube channel. Well, this is the lecture number 11 today, and currently we are discussing the fundamental rights. Before we'll start, I would like to give you the brief introduction about this initiative so that if you are new to our channel, you will get more connected with us. From 2nd June, we had started this initiative, and the name of it is Target IAS 2026. And under this initiative, every day we are uploading two videos on our platform. The first one where we discuss the current affairs in very detailed manner. We discuss the topics with respect to your prelims preparation as well as mains preparation. And in the evening session, we upload another video where we discuss the static syllabus of yours. And in the static syllabus, we had started with Indian polity. You know why we are doing this? Because we want to give this free coaching to you guys, and under this initiative we had promised you that by the month of Jan 2026 we'll try to complete your full syllabus, and we'll try to cover every subject which is required for you to clear this exam, whether it would be related to prelims or mains. We will try to cover every subject, every topic which is required for you to clear the exam. And there is an exception to it, which is we are not conducting classes for the optional subjects. That is the only exception here, and also the language subjects. So this is about the initiative. If you want us to be the part of your journey, so please do subscribe the channel and do share it with your friends so that they may also get benefited from this initiative. And also one more thing I would like to mention here, that as much as these videos are important for you, at the same time the notes are also important for you, from where you will prepare. In the class here we will try to we will try to discuss every point which is important for you. We will try to bring in every fact, but we have the human errors here, we have the human tendency, and there are many facts which we may forget. So for that we are right now developing the notes for you guys, with respect to this particular subject which we are teaching here. Right now we are teaching Indian polity, so with respect to Indian polity we are developing the notes for you, that too. And in those notes we will contain everything what is required for you. We will discuss the concepts, and at the end of the discussion we will also bring the possible prelims or mains related questions also there, so that it will give the proper idea how important these topics are for you, and how examiner can ask questions from these topics. So we are developing these notes at the end of these lectures, and we will complete the syllabus of Indian polity. Those notes would be also available, and if you would want to get those notes, you would have to pay just 200 rupees for per subject. For example, if for polity you want those notes, you will have to pay only 200 rupees and you will get the notes, and trust me, they would be very much different from your conventional books from where you read. If it is very much optional, if you want to buy, that is good. If you don't want to buy, that is bad for us, and that is okay. Now without any delay, let's start our discussion from where we left yesterday. Right now we are discussing the fundamental rights, and in fundamental rights there are set of rights which are given to us, right? Like a right to equality, a right to freedom, and right to freedom of right against exploitation, and then right to freedom of religion. So these rights are given to us, and many more. But here what we had discussed so far, we had discussed right to equality, article 14 to 18. We discussed them in a very detailed manner. If you want to have a look at these lectures, please go to my earlier lectures. We had just given 11 classes till now, 10 classes till now, so it won't be much. So please go to my earlier lectures, and you will understand better what we had discussed. After that we have the right to equality we discussed, then right to freedom from article 19 to 22. We discussed them in a very detailed manner, and we completed them yesterday. Now we are discussing, now from today we are going to discuss we are going to discuss right against exploitation, which are contained in article 23 and 24. After that we will discuss the right to freedom of religion. We will discuss right to freedom of religion. that we will discuss also today. So these are the these are the articles which we have to discuss. We have to discuss from article 23, 24, 25, 26, 27 and 28. These two would come under a right against exploitation, and these four would come under a right to freedom, a right to freedom of religion. So this is what we are going to discuss today. Now, without any delay, let's have a look at the first article which we have to discuss, that is Article 23. Let's see what does Article 23 say, what are the important points which we need to discuss here, and how can UPSC examiner ask a question from this article. Here let's have a look at Article 23. Here I had briefed Article 23. As you can see, Article 23 of Indian Constitution is crucial part of right against exploitation. It broadly prohibits two major forms of exploitation. What are these two major forms of exploitation? First, traffic in human beings. Second, forced labor. Now let's discuss these. What is this traffic in human beings? What is this traffic? And what is this forced labor? Let us discuss them one by one here. Let's try to discuss them one by one here. Let me rub it first, then we will start our proper discussion. What is this traffic? What does it mean? You know, if you will go back to a few hundred years, there was a thing which was very much, very much accepted by the societies, by the elite. Usually during our medieval times or during the ancient times, whatever elite thought right, that was right for everybody. Lower class people, they did not had anything to say. So what was accepted by the society, that there was one thing was very much common, that is slavery. The concept of slavery, that you can buy and sell the human being. You can buy and sell the human beings like the goods. You can be indulged in this business. There would be, if you will go back into the history, you will see that there would be a man, or a pimp, we can say in the modern terms, that he would have, or the agent, he would have many slaves with him, he will have many people with him, many human beings with him, and there would be rate for them, that at particular rate you can buy that particular person for whatever reason. If it is woman, you can buy it for the sexual purposes, or for other purposes. In simpler terms, you could easily buy or sell them. So this is what was very much in continuation, in our society, till the we can say till even during the British era. So that's what it has been. It was very much, this is very much exploitative, very much exploitative. It would exploit, it will exploit the freedom of the person. It will exploit, it was so disgraceful for the human beings, for the people who were forced to go who were forced to be the part of this business. This was very much exploitative for them. And the constitution, we believe in the democracy, we believe in the equality of the people, we believe in the equal protection of the rights. So it was very much important to end this business, to give a final end to this business, and this Article 23 was brought in. What does Article 23 say? That traffic in human beings, which is buying and selling of men and women like goods, it has been totally banned in our country. It is totally prohibited in our country. And so here is the question: this if it is the traffic of human beings is banned, what about the traffic of human organs? Is that also banned in our country? 100% that is also banned, that is also prohibited in our country. You cannot be trafficked, your organs cannot be trafficked. So this is totally very much prohibited under Article 23. Now the question here comes to our mind, that what about prostitution? What about prostitution? Is prostitution legal? Is it totally prohibited in our country, or there are certain ways the prostitution can be done? So this is the real question to which we need to have the understanding of. If prostitution is done in a private way, in a private property, and the public is not indulged in it, it is not done it is not done, this prostitution is not done is not done, in which you set up a brothel where the customers will come and the pimps will manage them. If it is not done in this way, and there is very much privacy in it, there is very much it is away from the public order, then this prostitution is very much legal. If it is away from the public order, if it is away from the this prostitution is done away from the public places, there is no proper brothel for that, there is no proper, there is no management, they are not forced by anybody. If it is done in that way, it is up to the will of the person, up to the will of the woman. If she wants to indulge in the sexual activity, so she can do it, but not in a public place, not in a way that it will give the sense that this public brothel is in some particular area. So that having a public brothels or pimps, doing prostitution like that, in which you are managed by pimps, or there are brothels for that, then this is very much illegal, because you have to, in a if this is organized prostitution in the form of brothels and pimps, then it is very much illegal. But if it is away from the solicit customers at public place, then, if it is away from the public places, then this is very much legal, then prostitution is very much legal. For example, you want to be indulged in a prostitution act, you can call some, you can do it at a very private place, but you cannot have a prostitution, you cannot do prostitution openly in the public place. You cannot do it openly in the public place. At the private place you can do it. So this is about the prostitution. Now here is the discussion, about should prostitution, should prostitution be totally legal, or should it be totally illegal? Now there can be a discussion over it. Is should government frame laws with respect to the prostitution? Should they make it totally legal or totally illegal? What are the different views? Such questions can be, they are not going to ask you in the prelims exam about the questions related to prostitution. Neither most likely they are not going to ask you in the mains exam too. But maybe in the interview they may want to check your where you stand with respect to your intellect, where is your mental intellect. They may ask you a question about the prostitution. Should it be legalized? Should it be fully legalized? Should, like we can have open brothels in our society, should it be legalized in that way? Such questions can be asked in the interview. So for that we have certain arguments which are in favor of that, and certain arguments which are against to it. Now let's have a look at the prostitution. If you say it should be there, what are the arguments in favor of it? The first argument which we can highlight, in an interview, is that we believe in liberty, equality. We have this equality of thought. We have this freedom of choice. We have this this morality of the constitution is based on the liberty and freedom of choice. Liberty and freedom of choice. So by making it illegal, we are restricting the freedom of choice of many people. We are restricting the freedom of choice of many women who want to, by their will, they want to get involved in these sexual activities, and they want to earn money from this. They want to have a good living from this. Why we are obstructing this business for them? So there is a liberty in our constitution. Our constitution provides us liberty. Our constitution provides us freedom of choice. Why not we let them do whatever they want to do? So this is one of the argument which we can make. Then the second argument which we can make here is that this prostitution, if it is legalized, if this prostitution is legalized, it can be a source of income for the government also. If it is legalized, then it would become the formal it would be a formal work. You can get government can charge taxes. Government can charge taxes on the prostitution, and it will be the source of income for the government also. As we had seen, the prostitution, it is the oldest profession in the world. from when this society has developed, from the times the societies has developed, these cultures have developed, or the civilizations have developed, this thing has always remained there. If we will go back into the history, we will see during the Mauryan times this was there, during the Gupta times it was there, during whatever time you will go back into the history, you would see that prostitution, especially in India, it was there. So it was one of the highest sources of the taxes for then governments, for then kingdoms who were ruling those areas. So it can also be the source of income for the government. So this is the another thing which we can highlight here in favor of, we can give this argument that it can be the source of, source of income for the government too. Then also we can highlight that, you know it may reduce or end the exploitation of women who are presently indulged in this act of prostitution. So how it is going to end the exploitation? Now it may seem little contradictory to our discussion that the prostitution itself is the exploitation, and it is highlighted that it is one of the exploitation, that women are exploited. Then how legalizing the prostitution can end the exploitation of women, especially who are in this business. Right now it is not that much legal, even though it is somehow accepted, but it is not that much legal that you cannot openly do the act of prostitution. There are many brothels in our society too, but they are very much under the they are very much under the radar of the police. They are illegal, but police are taking the bribes. The police may take the bribes from those prostitutes, and also they are managed by many pimp or many managers. They also have to pay to them, and if they try to refuse that money which they are earning through this act, if they try to refuse to give this money to the police or the managers, then they may fall, they are exploited there, they may be challenged by the police. They are forced by the police that if you are not giving us the money, we will put you under, we will put you under custody, we will throw you in the jail. So in this way these women are exploited. And if the prostitution is legalized in our country, then how it can help them? It can, they can refuse to pay any money to them, and they will, if they are earning, if this is the source of living for them, then they can earn much more from it, and pay also the taxes. Then also one of the reason highlighted is this may be the way in which we can control STDs, sexually transmitted diseases. And it may also seem very much rare for the discussion that how we can control STDs by this act. It in a way seems that it is one of the source of the STDs. But here one thing you have to understand. Right now, prostitution in itself, in the public places, it is very much illegal, and it is not, and the prostitution that in the public places is very much accessible to the people. So here is the point. When these people visit these brothels, and they go to the woman for the sexual act, what they do? They throw themselves on those women without using the contraceptions. And if woman refuses, then these men who are physically stronger than the woman, they torture that woman, that what you can do about it. You want to go to the police, then go to the police will do nothing to us. Rather they will confiscate the property. They will this act will affect your profession, not ours. So in a way, a woman is exploited, as well as there is further transmit of the diseases. But if it is made legal, now if the people will come, there would be, woman will have all the right to ask the men to have the contraceptions. And also, there would be the health certificates hanging on the doors that this particular woman, she is healthy, she had done all the tests which are required for controlling the sexually transmitted diseases. So it, in a way, in this way, if it is legalized, everything would be legal, all the tests would be legal, they can easily open up themselves, and this will further reduce the STDs. And also one of the thing which we can highlight, that it can lead to the empowerment of women. When women have the access there, right now the women, why they are not that much empowered? Because they don't have the economic strength, they are not earning the money themselves. Because of that they feel they are not empowered enough. They don't feel that they are as worthy as men. But once they have this money in their hand, then it will definitely empower the generations. They can spend, not every woman is educated, but every woman has this dream that their children should be educated. If they have the enough money, they can invest in their children. Can invest in their girl child, and they will empower their careers. They will they will impact their careers, and they will empower that girl child also, and it will also empower the woman, the mother also. So this is how these are the some arguments which are in favor of the prostitution, why it should be legalized. Now, as we discussed the arguments in favor, now let's discuss what are the arguments which are against the legalization of the prostitution, which is very much mandatory for a UPSC aspirant to know. The arguments which are against it, one of the major argument in favor of it is also said that if prostitution is allowed in India, especially in India, it will definitely reduce the rape burden in India, because these sexually frustrated men, they have nowhere to go, and they throw themselves on innocent girls, on the girls, on the woman. But if these brothels would be available to them, if the prostitution would be available to them, it will definitely reduce the rape burden in our country. This is also one of the argument which we can give here. And what are the criticisms against it? Let's try to discuss them now. Let's try to point out those criticisms. First, it is immoral act. The society is not right now ready to accept it. It is very much immoral. It is against the nature of the society right now. It is against the teachings of the society, so definitely it is not accepted. Second, it can impact the education of women. When women will start earning money through the prostitution, they will definitely understand that this is the easiest way to earn the money, and definitely they will be less interested. It may lead that they will be less interested in the education. And to this we can highlight the example. You would have heard about OnlyFans. This is one of the way that Western women, they earn in millions of dollars for that which they don't require any skills. So this OnlyFans can be the example here, that if this is made available, if this is made legal, definitely it will also have such impact that women will be least interested in the education, in the empowerment, in the skill development, rather than it would be easy for them to earn money. So this is also one of the drawback to it. Then it will destroy the family system in India. The family sentiments are very much against it, and definitely if a if a husband is interested in extramarital affairs like this, definitely it will lead to the highest cases of divorces, and it will definitely lead to much much destruction of the family structure. And also, as we discussed, one of the way it can reduce the sexually transmitted disease, but also it can increase the sexually transmitted disease. It can impact the STDs. Why? Because people can misuse this instrument in itself. They can bring in the fake certificates and all that, and it will further amplify this STDs. So this is, again, these are some arguments which are against the prostitution. Now, why we are discussing this, whether prostitution should be legal or illegal? Because we have Article 23. What does Article 23 says? It protects you. It gives the protection against against exploitation. And in Article 23 there are two types of exploitation. One is traffic in human beings, and in traffic in human beings we had seen, in traffic in human beings we see that how human beings are forced. They we cannot sell or buy them like goods. Similarly, slavery was abolished. And further, about the prostitution, how at the public places it can't be done. This is one of the way, one of the way it restricts or it ends the exploitation of human beings. Now another thing which is mentioned in the article 23, which is forced labor. What is this forced labor? Let's try to understand that. So traffic means exploitation. There would be, or where there would be no open buying and selling of the people. Then what it also prohibits, article 23, it also prohibits forced labor. And in forced labor we have the beggar system. Let's try to understand what this beggar system is here, uh, by some examples, what how it used to be there in our country, and let's try to understand that. So this beggar system, what is this? You know, before independence, what used to be the situation in our country. Suppose it was a family there and they wanted some amount of money, and at that time there were no banks. So where from, and the relatives were not that rich that they can help them. So where from they will get this money? They will go to the money lender, who will charge maximum amount of interest on this money which they will buy from him, which they will get from this money lender. Maybe 40% or 50% interest rate would be on that money. And after that, when they will buy this money, there is some situation in a family and they buy money from the money lender, and they now owe him huge amount of money, and this person dies, who had who borrowed money from this money lender. This person died. Now what will happen to his children? His children are not able to pay this money back to him. Now his children were forced, his children were forced by this money lender to work for them without being paid anything. His children were forced to work for the money lender without being paid anything. So in this way, it was this debt burden always remained on them, and they would have to work for this without being paid. So this is how this beggar system came into existence. This is how this exploitative practice came into existence. This beggar system came into existence. So in this way, there, what was there? It was the forced. They were forced to work. We can say it was the forced labor. And also there is another term which is not paid enough wages. Not paid enough wages. It is not only that you are forced to work and paid nothing. Another way to exploit the worker is that you will you want to do any construction, you will get the workers to do that, and for that, for that construction, you will tell them to work for infinite number of hours, and you will pay them least amount of money. So this also comes under the exploitation of human beings. This also comes under the exploitation of human beings. This also comes under the beggar system and bonded labor, where a person is forced to work to pay off a debt. This is the bonded labor or beggar system, where without remuneration, you are not paying anything to them, or you are forcing them to work extra hours and you are not paying enough money to them. So this is also restricted under this act, article 23. Article 23 protects a person against the exploitation, and exploitation can be traffic in human beings, that you cannot buy or sell a human being. And second way, you cannot continue the forced labor, that you cannot have the practice of beggar, where you will go for the bonded labor. You will not pay anything for the work they are doing, the workers are doing, or you will pay least amount of money. You cannot do it. This is very much prohibited under article 23. So Article 23 of Indian Constitution, it is a critical part of right against exploitation. It broadly prohibits two major forms of exploitation. One is traffic in human beings and the other is forced labor. Now, is there any, what are the relevant legislations enacted in pursuance of Article 23? The first one is the Immoral Traffic Prevention Act of 1956. It was brought in. And the second one is the Bonded Labor System Abolition Act 1976 and Minimum Wages Act 1948. These acts were brought in relevance in pursuance to Article 23. So this is so far about the Article 23. I hope you had understood it. What is the exception to it? Let's see if there is any exception to it. Article 23 exception. Yes, 100% there is an exception. For example, suppose you had committed any crime, and you are in jail now. You are in jail, and there you have to work, rigorous imprisonment, and you will go through the rigorous imprisonment and forced labor. In jail, you would be forced to work, and for that you will be paid nothing or very less amount of money, and that is the exception to this Article 23. And also state one in jail where you have to work, you will be forced to work, and for that you may not be paid anything or very least amount of money. Second thing, what is the second exception to this? State can impose compulsory services, like in the military services or social services. State can impose these compulsory services like military and social services. For example, there is tsunami and you want to rescue the people, then state can impose this restriction on the people, and this restriction to this article, that they will force people to rescue the people who are who have the swimming ability. They would be forced to rescue them. Or if there is any war, for example, recently we saw that India and Pakistan, we had this clash, Operation Sindoor. During that time, if the situation would have worsened, then the state would have asked, forced the people in certain age group to come in and join the army. So this is the exception, and for that state may not pay anything to us. That is the exception to it. And this exception can be done, but state has to look into certain things on which basis they cannot do this exception. What are the basis for this exception? You cannot force certain people on the basis of religion. You cannot discriminate on the religion here, that you belong to particular religion, then you have to jump into the water. You belong to particular religion, then you have to go to compulsorily join the army. This cannot be done, and this discrimination cannot be done. Second, discrimination on the basis of race, it cannot also be done. On the caste, it cannot also be done. Or class, it cannot also be done. Otherwise, if there other discriminations can be brought in. For example, on the basis of age, certain people under certain age group, they will be forced to join the army. Or on the basis of sex, if you are a woman, then there would be certain certain things which you would not be supposed to do. If you are a man, then you would have to join the army. So these restrictions can be brought in, but on these basis, on the basis of religion, race, caste and class, on this basis you cannot force anybody. You cannot violate Article 23 on these bases. So please, this is about Article 23 in nutshell. I guess I was able to explain this Article 23 in a very detailed manner, and what are the exceptions to it, and what are the various acts which were brought because of the Article 23. So till now, I hope you had understood it. Let's recap it. What does Article 23 say? Article 23 is basically talking about the right against exploitation, and there are two types of exploitation. One is traffic and another is forced labor. So is this absolute right? No, it is not absolute. There is an exception. What are the exceptions? First, if you are in jail, then you would be forced to work for very less amount of money or for no money, or state can impose certain job on you, compulsory services on you, which you would have, where you would be forced to do that. So this is the exception under Article 23. So with this, I hope you had understood the Article 23 in very detailed manner. Now let's move to Article 24 and let's try to understand it. Let us see what does the Article 24 say. Article 24 of the Constitution specifically prohibits the employment of children in factories, etc. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. Important laws which were enacted based on Article 24. To give effect to Article 24, the Indian Parliament has enacted several laws. For example, the Child Labour Prohibition and Regulation Act 1986. So what does this Article 24 is talking about? It is talking about basically about the employing of children below the age of 14 years. It prohibits the employment of children below the age of 14 years. Because of this prohibition employment of children below the age of 14 years, why it was important? Because we can see that we have the right to education. We have the compulsory and free education from the age group of 6 to 14 years. So definitely this was very much in need that these children should not be forced to work. They should not be forced to work. So because of this Article 24, which is it prohibits employing of children below the age of 14 years, because of this the law was enacted by the Parliament, and the law is the Child Labour Prohibition Regulation Act 1986. In 1986 this law was enacted. What is this? The Child Labor Prohibition and Regulation Act of 1986. To this act there had been many amendments done so far, and the latest one which was very much which we can say a trademark amendment, it was done in 2016. The trademark amendment, it was done in 2016. Now let's try to understand it through this. Let's try to understand Article 24 through this act, which is the Child Labor Prohibition and Regulation Act 1986, before 2016 and after 2016. Let's try to understand the impact of this act before 2000, about the impact of the act, which is Child Labor Prohibition and Regulation Act before 2016 and after 2016. So what is the difference here? Let's try to understand that. Here Article 24, what does it prohibit? It prohibits the child labor below the age of 14. So before 2016, it defined a child. Who is the child? Who is less than 14 years. He is a child, and he is prohibited to employ in, he was prohibited to be employed in hazardous industries. So it was the scene before 2016. And another thing, in non-hazardous environment, he would be allowed to work. In non-hazardous environment, he would be allowed to work. In non-hazardous environment, he would be allowed to work, but the hours of the working would be regulated by the government. These were a few important provisions of this act before 2016. If we look at this, why this child labor prohibition and and regulation act was brought in. If we look at this, if we will try to understand it, the Child Labor Prohibition and Regulation Act 1986, this act was brought in 1986. So what does this say? It shows, it basically, whenever any law is made, whenever any act is framed, whenever any act is given to us, or any amendment is made to us, it has wide spectrum. We don't need to just understand the act. There is no it is not limited to the political understanding but also the economic understanding. After the independence, we know that how the economy of our country was, how the people in our country they lived, what was the poverty status in our country. So at that time we could have not afforded to bring in such laws, because the major focus of the people was to earn the bread rather than to send their children to the school. So at that time we could have not afforded it, but by the time when our economy improved, so these things also improved. So this is the connection why these amendments are brought so late, because our economy improved to that level. And also what was brought in, because the right to education, it was made the fundamental right. We saw in our yesterday's class also. So because when it was made fundamental right, when there was compulsory education for 6 to 14 years children, then we need to bring in the act which would be in line with that. We need to amend this act which would be in line with that, and this amendment was brought. So that's why it looks like that. So what was the situation before 2016? A child was defined below 14 years age. He was not allowed to work in the hazardous environment, but allowed to work in non-hazardous environment. And the hours would be regulated by whom? It would be regulated by the government. Now what is the situation after 2016? After 2016 the situation is little different. It also defines child below 14 years age, but also it also defines the adolescent between 14 to 18 years. For child, it is total prohibition of work. He will not be allowed to work, whether it would be hazardous or unhazardous environment. But there is exception. What is the exception for the children, for the child? Exception is that he can work in audiovisual industry. He can work for the family if they run the business and that is not hazardous, then he can work there. These are the exceptions. What about circus? That is also entertainment, but he cannot work in circus, because circus in itself is the exploitation. So he cannot work in circus. But in audiovisual industry, for example in films, they can work, but the timing would be decided after their schooling time. What is the schooling time? After that they can work in these forms, or for the family or the audiovisual industry after the school timing and in the vacations. So this is for the children. And there was adolescent was also defined under this act, and adolescent was between the age group of 14 to 18. For them, they cannot work in hazardous environment, but in unhazardous environment they can work. So this was made. These were the changes which were made after the 2016 Amendment Act. These were the changes made to Child Labor Prohibition and Regulation Act. So these were the changes which were made after 2026. So what if anybody goes against it? What if there is a person who is sending their children, or there is a company who is appointing, there is an industry who is appointing children below age 14? What will happen to them? They will get punished, either the 20,000 fine or 50,000 fine or 6 months jail or 2 years jail. It would be the term for their punishment. But here is the question: who will be punished? Is it the industry who is appointing them, or is it the family? Majorly it would be the industry, but if the family is forcing them, then it would be the family. Now here is the question: we have this Child Labor Prohibition and Regulation Act. Now we discussed them. We saw that how earlier before 2016 how it only defined a child. After 2016 it defined the child as well as adolescent. We saw that what were the exceptions given in it in Article 24. But here is the question: is it good? Is this law, is this act in itself good, or is it bad? So let's discuss this. Let us discuss this in a little detail. What are the arguments which are in favor of this Child Labor Prohibition and Regulation Act, and what are the arguments which are against it? First, let us discuss what are in favor of it. First argument which is in favor of it: it prohibits the engagement of child below 14 in all occupations. So it will give him the time to study, it will give him the time to go to school, and definitely it will protect the rights of the children. Definitely this law is somehow protecting the rights of the children. Then second important thing about this law which we can highlight, that it defined the first time the term adolescent. It defined the first time the term adolescent, and it defined their rights also, how adolescents were they were exploited. It restricted their work in certain specific industries, and how it protected their rights also. So this is a good thing about it. And also this law, it is in line with the right to education. This law is in line with the right to education. And also we saw that what was the exception to it. The exception was that you can work in the audiovisual industry. So audiovisual industry, what is that? It is something where you show your talent, where you can improve your talent. You can be the next Shah Rukh Khan, you can be the next Salman Khan, you can be the next Rajni Khan, if this opportunity is given to you from the childhood. So definitely it helps them to reach that climax of which you have the talent of. So definitely it is good thing about it. And also it allows the children to work for the family business. It will help in transferring the skills what your parents had into the children. Definitely it is also a good sign about this article. It helps in ensuring that the skills of the parents to pass on to next generation. And also it has given those who violate the term, they have well defined penalties in this act. So these are some good things about it which we can highlight. For example, prohibits engagement of children below the age of 14 in all occupations. First time law deals with the adolescents. Law is in line with the right to education. The law factors in formation years of child to whom her skills or creative skills what they have. It ensures the skills of parents to pass into the next generation. And also those who violate these laws, who violate this act, they will be punished severely. So these are the arguments which are in favor of this act. And what are the arguments which are against it? One of the argument may come to your mind that it is not economically friendly. There are families in our country who are so poor that they depend on their children to work. But this cannot be this argument against it. And you cannot highlight this issue. For that, this is something which we are for that it is like we are treating the symptom, not the problem. So what are the problems? I will tell you. This is how you should think as an UPSC aspirant. First, it does not define the maximum number of hours a child can work after schooling. It can exploit it. The parents can exploit the child, or the industry can exploit the child. Audiovisual industry can exploit the child after their schooling, because it does not define the maximum number of hours for which they can work. And also when these children are working in the audiovisual industry, we know that audiovisual industry, it can have the reality shows. And one thing about reality shows is that they are not so much real. So these children would be forced to fight with each other. They would be forced to cry. They would be forced to show some incorrect activities, immoral activities. Definitely it will impact the psyche of the children. And also when these children are performing in the audiovisual industry, for example, they are performing for some show, they get this development in the mind that either they have to be winner or they will be the loser. So this idea is put into their mind from the very beginning age, at the age where they should had played, they should had enjoyed their life. But this premature this term, the premature maturity which comes to them, premature psychological maturity which comes to the children, it is very much harmful for them, because they did not mingle well with with the people in their age group. They cannot play with them, and it definitely impacts their childhood. So these are some of the ways. These are some arguments against it. And also with respect to the adolescents, as this act has agreed that they can work in non-hazardous companies or industries. But what is this non-hazardous industries? If we look at the data, earlier we used to have 70, earlier we used to have 82 non-hazardous, we used to have 82 hazardous industries. Now we have only 3 hazardous industries. Definitely the definition has been changed. We cannot change the nature of these industries in a whiff. We definitely had changed the definition, and these are the same industries which were earlier hazardous. Now they are unhazardous. Definitely it is going to impact the adolescents who are going to work in these industries. And also, if we look at it, permits that you can work for the family, and you can it will lead to the transfer of skills. But if we will see in our country, the caste system is based on the skills which our parents have. So definitely it is going to further going to give emphasis on the caste system in our country. It will further continue, rather than what the government should do. They should hire these teachers with such skills, and they should give these skills, for example carpenting skill or other skills. They should give such skills into the children who are studying in the school, so that everyone will learn that, so that we can preserve these cultures. So these are some of the arguments against it. And also we can say under this that in this whole discussion about the child labor, we are one thing which we are ignoring, that why are people forced to send their children for earning, why there is child labor in our country. The major reason is the economic background of the family, where there are families who are very much poor, and they are forced for the child labor. So what we are doing right now, we are treating the symptoms. We are not looking at the actual problem. The actual problem is eradication of the poverty, and how it can be achieved. That if we will give them the pensions, if we will give the family the pensions, then only we can reduce this child labor. And this model was seen in one of the districts of Maharashtra or MP, I don't remember that, where the administration, they collaborated with the panchayats, and the families, they were in a way forced that they should send their children to the school. And finally, now the enrollment rate of that particular village is 100%. And one of the way it was done, that their debt was in a way, I don't remember the name, it was recently in the news, the debt of the people, that was almost reduced for them by the authorities. So this is actually this is the problem, that the eradication of the poverty, it is the real problem, because of which all these child labor is there, exploitation of children is there. If this poverty would be eradicated, then definitely all the issues would be sorted out by itself. So this is what article 24 says. It talks about it protects the children from exploitation. It talks about the prohibition on child labor, employing of child labor below the age of 14 years. So it is definitely protecting them. So this is about article 24. I hope you had understood it. If there is any confusion, please do write in the comments. I will try our best to clear that confusion. So please do note down what were the points which are in favor of it, and what are the points which are against it. These may be very much relevant for your mains exam. That's why we are highlighting it. I would have just given you the articles and moved on. We would have completed full fundamental rights till now. But it is the necessity that we have to discuss all these issues in a very detail. Now let's see further what is given in this article now. And then now the term we have to discuss, the right to freedom of religion. We had discussed article 23, exploitation against what? Against traffic and forced labor. Second, article 24, exploitation against child labor. Prohibition against exploitation of children. It is against child labor. Now we have to discuss. We discussed the fundamental right, important fundamental right, which is right against exploitation. So this is very much clear now. Now let's move to the Article 25 and let's start with the right to freedom of religion. Let's try to discuss this Article 25, then we will move forward. So let's try to discuss it. Article 25. So what is this Article 25? Let's first get the highlights of it. Article 25, it primarily deals with the freedom of conscience and the right to freely profess, practice and propagate the religion. What does it deal with? The freedom of conscience, the freedom of conscience and the right to freely profess, practice and propagate religion. So let's discuss them one by one. Let's try to understand them one by one. First, freedom of conscience. What is this freedom of conscience? This is the innermost thought of a person. You cannot alter, you can do everything. You can force any person to do whatever you want him to do. But this thing, you cannot control the innermost feeling of a person. This conscience is the innermost feeling of the person. You cannot change it. You cannot force anybody to change it. This is something which is there, which would always be there, and it will define. This will define what your thought would be, what your belief would be, what your religion would be. It is something which a human has, in which is given to us by the God, or whether you believe in God or not. This is something which is in us by default. This freedom of conscience, it is something which we have by default. This is something which we have by default. So what does the Article 25 says? It primarily deals with the freedom of conscience. So this is the freedom of conscience, that the innermost thought, you can have whatever innermost thought you want to have. You can believe in religion, whether you want to believe in. You can be the atheist, which means that you are believing that there is no God, or you can be the agnostic. You can have this feeling that maybe there is God, maybe there is not God. I don't know. You can have any feeling. You can have the faith in any religion. You can be a Muslim. You can be a Hindu. You can be a Sikh. You can be a Christian. You can be whatever you want to be. Nobody can stop you. You can believe in whatever you want to believe in. You can develop your own religion. Nobody can stop you. This is something the conscience is. There is the freedom of conscience, and you cannot alter that. This is what the conscience is. And the second thing, what does it say? Second thing, it says that freedom of conscience and right to freely profess, practice and propagate religion. So after you have the freedom of conscience, now you choose, you understood something, that particular religion or particular faith is good for me. Now you want to profess it. You want to profess this faith. You want to tell to the world that you are following this faith. You want to tell to the world that I am a Muslim, I am a Hindu, I am a Sikh, or whatever you are. You have this right to profess this faith. Once you are professing this faith, now you can also practice its tenets. You want to practice your religion, you can practice it. This freedom is given to you. You want to offer the prayer 5 times a day. You want to do the puja. You want to go to the church. You can do it. First you have the conscience. Then you want to profess what your conscience says. Then you want to practice it. Then now you want to propagate it. You can propagate your religion. You can propagate your faith. You want to invent your own religion. You can invent it. You want to invent the tenets of your religion. You can invent it. You want to propagate the religion of Islam. You can propagate it. You want to propagate it in you want to propagate the good things of it. You can propagate it. There is no restriction to it. Now the question is this propagation, can this propagation lead to conversion? Can you convert anyone? That is the question. Can you convert? 100% you can convert. If you are Muslim today, you can convert to any other religion. If you belong to any other religion, you can easily convert to Islam. This is up to you. There nobody can restrict to you. But can you convert another person? That is the question. There are the limitations. There are some things which you have to look after. And about this article, you know about this article, there is one thing, with respect to the right to freedom of religion, one thing you will see, that is, earlier whatever article we discussed, for example, we discussed article 14, article 15, we discussed right to freedom of expression and speech, all that stuff. In all those articles, whenever there were exceptions, they were given, or restrictions were there, they were given at the end of the article. But in these articles, with respect to the right to freedom of religion, in these articles, the exceptions are given, first, then the article is given. So in these articles, the exceptions are given first. What can be the exceptions? What can be the exceptions to this? What can be the exceptions? Exceptions are, you know exceptions, limitations to this exceptions can be public order, exceptions can be morality, and exception can be health. These can be the exceptions or other provisions of this part, which is part 3 of the Indian Constitution. Now let's try to understand while these exceptions one by one. Let's try to understand these exceptions one by one. Let's try to discuss them one by one. So first exception to it is public order. Now let's assume a condition here. Suppose you are a Muslim and you are a Shia Muslim, and Muharram is here. You have to celebrate the Muharram. You have to go outside your house and you will celebrate it in your way. And at the same time, in your society, there is the Durga Puja, and they are also going to celebrate this in their way, how they celebrate it, how they conduct this Durga Puja. They, in their way, they are going to do it. Now there is a certain area in which both of the communities are planning to celebrate it there. If both the communities are going to celebrate in this particular area, definitely the condition will not suit both of them, because there would be the people who will rise to violence. There can be the clashes between the two communities. So here the state will come in, and it will consult the Muslims, tell them that go to the particular area, celebrate in the particular area, and to the Hindus it will tell them that you have to go to the particular area. Now you wanted to celebrate it in this particular area, the state is not letting you to celebrate it in this area. Now you would go to the court and tell the court, sir, we have the article 25 which allows me to profess, propagate and practice my religion. But I want to practice my religion, I want to practice the Muharram there. The state is not letting me to practice it. It is against the violation of my article 25. Similarly, the Hindus will approach the court that we want to do the Durga Puja, state is not allowing to us. The courts will call the state, why are you not allowing them? The state will say that, sir, there are chances of the clash between the two communities, because they are where they are demanding to practice their this act, it is common to both. So there are high chances that it will impact the public order in this region. So we want to restrict this right. We are restricting this fundamental right of theirs to practice their religion because of the public order. Then the court will say, courts will clap. They will clap there. They will appreciate the police. They will appreciate the state, and they will tell them you had done the good thing. If you would have allowed it, there would have been much cases, and the burden on us would have been more. So you had done the good thing. You had not allowed them to work in this, because to practice in this particular region, because it would have impacted the public order in that particular region. So the first exception to it is public order. On the basis of public order, it can be stopped. So on the basis of public order, it can be stopped. What is the another exception? Another exception, what was given, what was the another exception given with respect to this? What was another exception given? Let me check it. Another exception is given of the morality. So on the basis of morality, it can be restricted. Now let me take an example of an innovation. How on the basis of morality it can be restricted. Let's try to discuss that. You know, in the Islamic law, if there is a marriage between the two people, you know, if two people they want to marry, you know, if there is a girl and a man, girl and a boy, they want to marry, for them in Islam it is not janam janam ka saath, it is not like that till the death we will stay together. In Islam it is a contract, it is a contract. In Islam the marriage is a contract where the boy will pay the meher, which is a dowry. In Islam the boy has to pay the meher, the man has to pay the meher, man has to pay the dowry to the woman, and man has to take the financial cares of the woman. If woman earns the money, that money is only of hers. Her husband cannot use that. But if husband is earning money, that he has to feed his family, he has to give the dowry to the woman. So with respect to this, if there is any clash between the man and woman, any clash between man versus woman in the marriage, so who can divorce? It is the man has the authority to divorce. Man has the authority to divorce. And what are the ways to divorce? There are two ways. One is triple talaq, which will complete in 3 months. It would be done into 3 installments. If today a husband will tell her wife, I'm giving you divorce, then after 30 days reconciliation will happen, arbitration will happen. If they did not agree, after 30 days there would be another talaq, and after 30 days then there would be the final talaq. So after 90 days this divorce is completed. This is the triple talaq which is mentioned in the Holy Quran. Then the another way is the instant triple talaq. So in this, what man does, a man instantly says talaq 3 times and he divorces his wife. He instantly says 3 talaq and he 3 times talaq term and he divorces his wife. So one thing interesting here is that once a man divorces his wife, he cannot then directly marry her again. If he wants to marry her again, he cannot directly marry her again, because you know you had divorced her, you had ended the contract. Now only you can marry her if this woman whom he has divorced, if this woman will marry some another third person and they will have a marriage life. And once that, if the third person who has married this woman, if he feels that the marriage is not working, and on his terms, on his goals, on his terms, he feels that marriage is not working, on his terms he will divorce this woman second time. Then if such thing happens, then only this woman will become available or become halal in the Arabic terms for this man, for his first husband. Let me again repeat it, this term. Let me again repeat it so that it will be very much clear for you. So what is this situation of talaq or divorce in Islam? Suppose a man divorces his wife, whether it would be instant triple talaq or the 3 times talaq, 3 in the 90 days. Now this man, he feels sorry that why he divorced her. He wants to remarry this woman. He cannot directly remarry this woman whom he has divorced in Islam. So how he can marry her? If this woman, she marries another man and they will have their married life, and unfortunately if this man decides to divorce her, or if this man dies, or this man dies or divorces her, or this woman takes divorce from her through the courts, if he is very degrading this woman, then only he can take divorce through the courts. Suppose they have the married life, they are enjoying it, and suddenly the man dies or the man divorces this woman on his terms. Now only this woman will be available to this man. Then only this man can remarry her, or this woman can remarry her first husband. So this is the Islamic ruling. This is the Islamic ruling. This is very much understandable. Now what happened? When this instant triple talaq came into existence, it has also a history. When you will understand the 90 days period of the talaq, there were many people who are very cruel and they don't want to divorce their woman, but they will put this continuous pressure on them for 90 days, then they will reconcile, then again for 90 days, then they will reconcile. They will not leave their woman alone. So for them, this instant triple talaq was brought in. It was innovated that if the man says talaq, 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 then the woman gets divorced from that person. So when this instant triple talaq came into existence, so what happened after that? Sometimes you may not be in a good mood, and sometimes out of anger, you will say anything. So when a man out of anger says talaq 3 times, so this woman becomes now haram for him. He cannot remarry him. So what they used to do, some of the men, they will force their divorced woman whom they had divorced to marry some another man. They will force their divorced woman to marry some another man, and then they will tell this man to divorce her. So this term is called halala. And this is very much against the Islamic teachings. Islam categorically, the Quran categorically, abuses those people who do this act of halala. So this term halala, if we look at this, it is very much immoral. Now coming back to our topic, why we are discussing this halala term, it is very much immoral, and this practice was very much common in the people who are uneducated people who had not enough knowledge of Islam. This was very much common in those Muslim people, in those Islamic people. So, and it is very much immoral. So what what government can do, they will come in and they will make this practice of halala as illegal, because it is immoral, which is also one of the restriction to the Article 25 of the Indian Constitution. The morality can be the basis for this restriction. Then the third term, it is the health. How can health be the basis of the restriction? For example, we are seeing that there was COVID-19 was there, and the first thing government did, it imposed a ban, or it ordered that the religious places like mosques, the temples, they should be closed. Now can the Muslims from the mosques, or Hindus from the temples, or the Christians from the church go to the court and tell to the court, sir, my fundamental right is violated by the state because they are not allowing us to go to the mosque? The court will be very much angry. Why state is not allowing you to do so? Court will call the state. Why you had stopped them? The state will tell them, sir, are you not looking at the environment right now? We have COVID-19. People are dying because of that, and it is highly, volatile. It transmits at a very high pace, and it has high mortality. We want to stop it. That's why we had put this ban on these institutions for certain time period. The court will applaud them that you had done the right thing. Otherwise, more people would die. There would be less taxpayers, and definitely it will impact the economy. The court will applaud them because health, as per Article 25, it is one of the reason for curbing this fundamental right. Then what is the another reason here highlighted? Other provisions of this article, which is part 3 of the fundamental right. What are these other provisions? Let's try to understand that. You would have heard about Sabarmala case. You would have heard about Sabarmala case, where in Kerala, this Sabarmala is Mila is there, which is dedicated to Lord Ayappa deity. This Sabarmala temple is dedicated to Lord Ayappa deity, and this Lord Ayappa, he is a Brahma. He was a brahmachari. He was a brahmachari, and once he was a brahmachari, that means that he has not married. He was never involved in any such acts. So there was rule formed by them. What was the rule formed by them? Any person, for woman, if they belong to the age group of 10 to 45, which is the menstrual age of the woman, they would not be allowed to enter this Sabarmala temple. And also, if men wants to enter, they have to sign an agreement that for 42 days they will not be indulged in this sexual activity. So this was the rule there. Now there was an association which did not like it, this rule. They went to the court. They argued that, sir, don't we have the right to freedom of religion? Sir, don't we have the right to equality under Article 14? Court said, yes, we have right to equality. Sir, can we be discriminated on the basis of sex under Article 15 and 16? Court said, no, you can't be discriminated on the sex. They said that, sir, don't we have the Article 17, which is against the untouchability? Court said, yes, we have Article 17. They said, sir, don't we have Article 25 where we have the right to practice, propagate, and profess our religion? Court said, yes, you have. Then the court said, what is your issue? They said that, sir, there is a temple, Sabarmala temple, where women are not allowed in the particular age group. Why they are not allowed? Because it is believed that they are in the menstrual age and they are impure for the temple. So isn't it the violation of Article? What? Isn't it the violation of Article 14? Isn't it the violation of Article 15, 16, Article 17, which talks about the abolition of untouchability? Court said 100% it is the violation of Article 17. We believed in untouchability. We had violated, we thought that we had abolished untouchability. So what did court give its verdict? It was heard by the 5-judge bench, and court gave the verdict that it is very much unconstitutional thing which is happening there, and this practice should not be followed because it is violating the other parts of the constitution, which we discussed here. It is other provisions of this constitution, which is the another which is the another way to restrict this fundamental right. Then moving forward, let's have a look at it. Then powers of a state to make laws, as for example, to protect this secular activity which may be associated with the religious practice. For example, state can also intervene under Article 25(2). Here under Article 25(2) grants the state the power to make laws regulating or restricting any economic, financial, political, or other secular activity which may be associated with the religious practice. State can intervene here. How? For example, with respect to this, we have the institutions. For example, Muslim, we had recently in the news Waqf board. For the administration of Waqf board, there should have been the Muslims who will administer it. But here, state has come up with the amendment that they had amended it. Now it is in the parliament. That the discussion is different. But how here state can bring in the secular nature? That suppose there is a temple and its management is within the Hindus will manage this temple, and they chants if any chants are spoken there, then the state cannot interfere with that. But where state can interfere here, that if only Brahmins are allowed to be the priests there, here state can intervene and state can implement that. All other religious groups can also, other Dalits can be the priests in this particular temple. So here the secular integrity, secular activity can be this secular activity can be respected in this religious practice. So this is what Article 25(2) also says. Then further, coming back to this Sabarmala case, practice, we saw that we are right now discussing what are the restrictions. One of the restriction was the public order. We discussed that. Another is morality. We discussed it with respect to the halala. Then the another is another restriction is health. We discussed that with respect to COVID-19. Then after that, if it violates any part of the fundamental right, we discussed that too. Now here is a question. As courts had discussed various instruments. For example, they discussed a case with respect to triple talaq. Shahbano case they discussed where the triple talaq was put down. They discussed the Sabar Millia case. Now there is the question. The question is that what is the secular what is the secular nature of our country? What is the secular nature of our country? And how can the state intervene? How can the state and the judiciary intervene? If we look at the secular nature of our state, of our country, it is very different from the other countries. We had discussed it in our earlier classes also. The secular nature in France is different, that if you are following any religion, then keep it in your private life. You cannot practice your religion in public. That is their secular nature. In USA, their secular nature is different. Your religion is yours, practicing in your way. In Australia, the secular nature is different. What religion you are following, it is your headache how you will follow the rules, unless there is any human rights violation. And the secular nature in India is different. We don't have a state religion. We will respect every religion equally, but if there is the need for interfere, we will also interfere. Now how can we interfere? For that, one principle was established. That is, the principle which was established is the principle of essential practice of religion. The principle of essential practices of religion. What is this principle of essential practice of religion? Let's try to understand that. Let's try to understand that what are these essential practices of religion. Then we'll move to article 26. Those are smaller articles that we can complete in 10 to 15 minutes, but here we need to understand it. What is this essential practice of religion? The courts said that it is not you. It is not you. By you, I mean it is not the religion who will define what is the essential practice of religion. It is us. The courts will define what is the essential practice of your religion. And if this essential practice of religion is in violation of the fundamental right, if the essential practice of the religion is in violation of the fundamental right, then this essential practice will remain. And if it is not an essential practice and it is violating the fundamental right, then the fundamental right will stand. For example, we'll take an example here. Example of triple talaq. Again, the famous Shahbano case. Example of triple talaq. Shahyara Bano case, which was heard by 5 judges. And in this 5 judges bench, 2 judges, they said that it should be struck down. It is unconstitutional and it is against the fundamental rights. 2 judges, what they said that this religion, it is something to kept with the people who follow it. They shall decide what to do about it. They are not going to comment on it. So they remained silent. In a way, they opposed the first 2 judges. And the remaining judge, what he said was very much interesting. His name is Justice Korean Joseph. He said that this instant triple talaq is not anti-constitutional, it is anti-Islamic. The way I explained to you earlier, this instant triple talaq, how it was introduced. It was not the basic feature of Islam. It was further introduced. They said the Justice Korean Joseph, he said that it is not this instant triple talaq. This is not the issue of the constitution. It is anti-Islamic and it should be read down. So this instant triple talaq, it is not an essential feature of Islam. It is not an essential feature of Islam. Even if it is not an essential feature of Islam, then we can easily struck it down and there is no issue, because the agreement which we had brought in, after this Sabar Millia case, the agreement which we had understood that if there is any, we had defined the essential features. If it is violative of the essential features, then the essential feature will remain. If it is not the part of the essential feature, then we will struck it down. And who are going to define the essential feature? It is the courts who will define. Courts will define what is the essential feature. So with respect to triple talaq. Now similarly with respect to Sabar Millia case, where it was decided that this it was made unconstitutional, and it was said that it is not an essential feature of this particular religion. So it was made very much available for everyone. But after this essential feature was given, it discussed various issues in particular in different religions, and it has seen huge controversy. For certain cases, when this question of essential feature was introduced, for certain cases, the reason why they are saying that it is essential feature because books talk so, because books say so. And for certain cases, for example, if we will take the example of triple talaq, for such cases, the books, for example, we can take the example of that Air Force pilot who used to shave. When he reached the court, he was forced to resign from the job because he had he was now bearded man. He reached to the court and he told them, "Sir, I have beard, and this is the religious practice. This is essential religious practice. It is in the Quran. It is in the Hadith. I should be allowed to be the part of the Air Force." The court said that no, it is not essential feature. Why it is not essential feature? Because the contemporary Muslims don't have the beard, so it can't be the essential feature. So the definition of essential feature in itself has become very much controversial, and because of this, it has become like the basic structure of the constitution, which changes by each judgment. So this the definition of essential feature, it is very much controversial, and it is to be looked upon by the 7-judge bench, which the Supreme Court has said that they are going to raise a 7-judge bench where they will discuss the essential feature. They will also discuss the Sabar Millia case, where in which the review petition was filled. The review petition for Sabar Millia case was filled. About the review petition, it should be filled within 30 days. Second, if there is any error in the judgment or new fact has emerged. None of these two were fulfilled, but still the Supreme Court agreed. It in a way reserved this. It put this review petition in pending, and these cases will be decided when the 7-judge bench will be set for such cases. And why it was put pending, this review petition for the Sabar Millia case? Because the courts highlighted the reason there are many such cases which are similar to it, which are similar to essential features. We are going to discuss those cases, and finally we will give a common judgment which will also impact the judgment about the Sabar Millia case. Whether this should be kept to the religious authorities, they will decide what are the essential features, or the judges will decide what are the essential features. So this is about the Article 25, right to religion, right to conscience, right to profess, propagate, and and practice your religion. It has the limitations, the limitations on the basis of morality, limitations based on the public order, limitation based on the health, and other fundamental rights if it is in a violation too. And also state can intervene if it feels that there is a need of the welfare, if it feels that the secular nature has been violated in a way that only the Brahmins are allowed to be the priests, there it can intervene. So this is all about Article 25, and we had seen various important cases with respect to it. Now let's move to the Article 26. First, let me rub all this because it is making it very uneasy for me. First, let me rub it, and then we'll move to Article 26. So till now we had covered Article 23, 24, and 25. I hope there is no confusion. If there is any, please do write in the comments. We are here to help you. We try our best to be very much precise and to be very much clear in that. And also at the same time, when we are delivering these lectures, we are framing notes for you where we had contained everything what you required to clear the exam. These classes are for the understanding purpose, and for the factual things you need to have the notes, and those notes we are preparing. What is important for you, we are preparing all that. And definitely if you will read these notes, I can promise you that if any question related to the static portion would be asked, you should be more than ready to answer those questions. Now here, let me rub it and start with Article 26. I hope Article 25 is very much clear to you guys. And let me go to the Article 26. What does the Article 26 say? Let's have a look. Article 26 states that the subject to public order. Here also we can see that the limitations are given at the top. Limitations are given at the top. What is the limitation? Public order, morality and health. Every religious denomination or any section thereof shall have the right. First, what is their right? To establish and maintain institution for religious and charitable purposes. A person can have their, if a religion is there, they want to establish an institution, they want to establish or maintain institution for religious and charitable purposes, they can do it, but there is limitation. One is public order. For example, you want to open a madrasa, you can open it, but limitation is public order. You should not open it near in that place, and you should not chant your religious verses in that way which can impact the public order. There, the state can come in and this right can be restricted. Similarly, morality, you should not do those acts which is against the morality. And also health, for example, during COVID-19 many institutions were closed, so these can be the restrictions for every religious denomination. These restrictions, if the state is bringing in such restrictions, this is for every religious institution. Here state cannot differentiate. Here state cannot bifurcate the people, that for particular religion they will bring in such restrictions, and if the same situation arises for the particular religion, they will not bring in this. They cannot do this. Would be same for every religion. Then the second thing, to manage its own affairs in matters of religion, and that we are seeing right now with respect to the Waqf bill, or the controversy related to Waqf bill, how it is pending in the parliament, and let's see what the judiciary will say about it. Many things would be with respect to the Waqf bill. What the constitution says, that you have the right to manage the affairs of the institute which you had established. You have the full right that you can manage the affairs of that institute. You want to have the spiritual teaching there, you can have that. You want to have the co-teaching there, you can have that. Whatever way you want to have this, you can have it, but these things you have to take care of: public order, morality and health. Then the third, to acquire movable and immovable property. You want to have the property, you want to have the assets like cars for your institution. You can acquire that. You can acquire land for your institution. You can acquire whatever you want. You can acquire that without any discrimination. And also, you want to administer such property in according to with law. To administer such property in accordance with the law, whatever law is, you have to administer that property in accordance to with that law. If the law promises, if the law demands that you have to pay the taxes, then you should pay the taxes. So this what Article 26 says. Article 26 states that subject to public order, morality and health, every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purposes. It has the right to manage its own affairs in matters of religion. It has the right to acquire movable and immovable property, and it has the right to administer such property in accordance with the law. So these are the rights which are given to you under Article 26 of the Indian Constitution. So with respect to this, let's move to the Article 27. Let's see what does the Article 27 says. Article 27 says, no person shall be compelled to pay any taxes, the proceeds of which are specified appropriately in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. Tomorrow, state cannot come up and tell you that you have to pay the taxes for the Ram Mandir temple. You cannot be forced to pay the taxes. You cannot be charged the cess. State cannot charge you cess for this purpose. No person shall be compelled to pay any tax. There you cannot be compelled to pay these taxes. This is the most secular nature of this act. It defines the most secular nature of our constitution, that you will not be forced to pay, you will not be compelled to pay the taxes in for the promotion or maintenance of any particular religion or religious denominations. But you can say that we had our country used to give the subsidies for the Hajj pilgrimage or for the other Kedarnath pilgrimage or whatever other pilgrimages are in our country. But that was very much common for everyone. You did not pay taxes for the Hajj pilgrimage only. You do not pay the taxes so that you will get the subsidies under the Hajj, or you don't pay the taxes so that you will get the subsidies under Kedarnath. So this is not something that you will pay the taxes and this will be maintained in this way. So that is different. But here what you have to understand, that you cannot be forced to pay these taxes for the promotion of any religion, like it used to be in the Mughal era, where you have to pay the jizya for your protection. This tax would not be commanded, would not be asked from you guys. So this is what Article 27 says. This is the protection which it gives. Now let's see what does the Article 28 says. Article 28 deals with the freedom as to attendance at religious instructions or religious worship in certain educational institutes. You cannot here the question is, can religious instructions or religious worship can it be allowed to be done in educational institutes? You cannot do it in the educational institutions, in particular educational institutions. For example, if the education institute is if it is wholly maintained by the state, then you cannot give the instructions or religious worship. You cannot give the instructions, or you cannot do the religious worships in those educational institutes if they are wholly maintained by the state. Then if the institutions are recognized by the state, if they are recognized by the state, for example private schools or private colleges, in such institutions these instructions can be given, the worship can be made, but it would be voluntary, not mandatory. In the government institutes which are wholly maintained by the government, you cannot give such instructions, or you cannot tell people to worship, tell the students to worship. In the private institutions which are maintained by the state, which are recognized by the state, here it is allowed, but on the voluntarily basis. If you belong to Jammu and Kashmir or any particular state, we have the habit of morning assembly, and in the morning assembly in our private schools, there we used to have the religious ceremony, and it was very much compulsory for every student. At that time we did not knew that, because we didn't never like to be in the morning assembly, because it was very hectic. There were many checks going on about whether you had cut the nails, whether your boot is polished or not. Everything was cleared there. If you clear all those disciplinary actions, then only you would be secured, otherwise you would be beaten to the hell. So if I knew it that time, I would have never attended the assembly because of that thing. So this is something, it is voluntarily based if it is maintained by the private, if it is maintained by the, or it is recognized by the state. And third type of institution in here is institution which is receiving aid from the state. For them also, it is a government, it is a private institution but receiving aid from the state. It is a religious institution receiving aid from the state. In here you can have these instructions or religious worships, but it is voluntarily based. Then the fourth type of institute is institution established by religious trust themselves. If the institution is established by the religious trust themselves, then in that they have the full autonomy. If they want it, they will have it. So this is about Article 28. It deals with the freedom as to attendance at religious instructions or religious worship in certain educational institutes. If it is wholly government, then you cannot have it. If it is recognized by government, it is voluntary based. If it is aided by government, it is voluntary based. If it is fully a religious trust, then it is up to them how they want to deal with this. It is allowed for them. So this is about Article 28. So till now we discussed right to right to equality, we discussed right against exploitation, and we discussed right to freedom of religion, which is from article 24 to article 28. So with this we complete our today's discussion. I hope you would like the video, I hope you would share it with your friends, and definitely I hope you would subscribe the channel. But yet we have to solve these few important questions, prelims based questions. We cannot leave without them. So let's have a look at the questions. Well, it is based on article 22. Article 23, it says, with reference to Article 23 of Constitution of India, consider the following statements. It prohibits traffic in human beings and forced labor. Correct. It applies only to state and not to private individuals or entities. No, it applies to both state and private entities. Article 23 and 24, they apply both to state and private entities. The state is completely prohibited from imposing any form of compulsory service for public purposes. No, they can impose. So with respect to this question, the correct answer is option A. Now let's move to the last question. Here the question says, with regard to the articles 24 of the Constitution of India, consider the following statement. First statement, it prohibits the employment of children below the age of 14 years in any factory or mine. Correct. The prohibition under this article extends to any hazardous employment but not to non-hazardous family enterprises after school hours. No. If the family business is non-hazardous, then these children can work there. The prohibition under this article extends to any hazardous employment, 100% correct, but not to non-hazardous employment, family enterprises after school. Yes, it is correct. This prohibition does not go to them. Third article, it says the article represents an absolute prohibition with no exception. No, there is an exception in here also, as we see in family employment or audiovisuals. So with respect to this question, it prohibits the employment of children below the age of 14 years in any factory or mine. Correct. So with respect to this question, the correct statement would be option B. With this, we had completed our today's discussion. I hope you would like the video. I hope you would share it with your friends and definitely subscribe the channel. Thank you for staying with us. Thank you very much and have a nice day.